Welcome to Case by Case. This is a podcast brought to you by Luke Sadkovic and Callum Chain from ZFZ. How are you today, Callum?
I'm good, Luke. We're obviously pre-recording this slightly, but I am feeling the festive spirit as we are ready to clock off for a Christmas podcasting break.
Yeah, well, this is a significant episode for a whole bunch of reasons. One, it's the last one of the year, as you say, and we're about to sign off the podcast for the year. I dare say we'll still have a few other things to do work-wise before the year ends, but podcast-wise, this is our last episode. But more importantly than that, we have some super, super exciting news to share. Not only will I continue to call Callum Chain a partner in podcasting, but from the 1st of January, we'll be calling him a partner in the law firm. Congratulations, Callum.
Thank you, Luke. Super excited. Really looking forward to it. It's been a great few years here at ZFZ, so it is really exciting to be taking the next steps on the journey and joining the partnership with you guys.
Yeah, exactly. Look, we're so excited, mate. You've done splendidly well. It's richly deserved. You're just such a great guy and a good lawyer, and most importantly, above all, just a great team player, and really a fabric and part of the ethos of the firm. So I'm delighted. I'm really looking forward to working with you as a partner. In many ways, things won't change at all, but in some ways, of course, they will. And it's no small feat to make partner at any firm. And hugely congratulations. It's a momentous occasion in your career, and one that I know you've worked very hard for, and you've given a lot to your clients, a lot to your colleagues and to the firm. So well done. And for anyone else out there wondering, basically the criteria to make partner at ZFZ is that you have to do 50 episodes of a podcast, and then you get it.
Then you're in, then you're home. And this is it. This is the 50th episode special. I managed to coordinate the two things to come together in one bumper podcasting episode.
Yeah, we did that well, hey. 50th episode. And hey, we were true to our word. You looked up after our last podcast, the 49th podcast, some statement where I said months and months ago we should try and hit 50 by the end of the year, and lo and behold.
10th of February. I had to do some digging to find that, but I remember it stuck in my mind as 50 being the target for the year, and there we go. It's all come together.
We deliver. Well, look, with that really happy intro, let's get into it. We're actually going today to do our third and final look back, if I can call it that, case, where as a part of preparing for an upcoming university course that I'm delivering on international shipping and commodities law, we've been looking at some old cases, not some recent cases as we usually do, but looking back at some old important cases. And we've had a trilogy of sale and purchase contract disputes in the commodity space. And this is another one where we're going to get into the depths of conditions in a sale and purchase contract. And importantly, I think it's a really useful follow-on from the last episode. So if you haven't listened to the prior episode, I'd encourage you to do so, because I think the two podcasts are going to nestle up nicely against each other, Callum.
Yeah, definitely. I think these last few that we've done all really do come together as a triumvirate of cases.
So where does that leave us in the Star Wars? Is this the Return of the Jedi? Is that the third one?
Yeah. A New Hope, Empire Strikes Back. Yeah, this is Return of the Jedi.
This is the Return of the Jedi. Okay, we're on to number 3. We're not worrying about the whole new series of Star Wars. We've just gone back to the good ones. No, I actually love them. I love them all. So, okay, what are we talking about? The case that we're going to... Actually, you know what? I'm going to just hand over this, because this is some kind of French word that, you are the master at pronouncing French. So I'm going to hand it over to you to butcher rather than me.
Yeah, I'm going to butcher this. It's something along the lines of Compagnie Commerciale Sucres et Denrees.
Wow. Now that sounds a lot better than what I would have said, which I won't hurt our listeners' ears by trying to say what I was going to say. And what? Czarnikow Czarnikow, who are the appellants.
Often you see the word Tsar, the Russian word Tsar spelled C-Z-A-R. So I wonder if it's kind of Czarnikow.
We need some help on that, I think. And look, this was a House of Lords decision, so went all the way up to the highest court in England at the time. So this was in the 1990s. It's now the English Supreme Court. Before five of the lords, Lord Bridge of Harwich, is it? Or Harwich? Lord Brandon of Oakbrook, Lord Ackner, Lord Oliver of Almerton, and Lord Jauncey of Tullychettle. Some fantastic names there, aren't there?
A veritable smorgasbord of difficult to pronounce names to get us going in this 50th episode special.
Yeah, I think some of those names were harder than the respondent's name. So, right, where do we start? Do you want to open this one up with a summary of the facts, Callum? I think it's probably a good place to start. Not that we need to spend a huge amount of time on the facts, I don't think, but it's probably a good place to start. I've got lots of thoughts on procedure again on this one, and also the substantive issues that were discussed, but maybe we start at the top, eh?
Yeah, let's start there. So this is a contract for the sale of sugar. The contract was entered into in December 1985. You had the appellants who were the buyers, and the respondents were the sellers. There's the appellants and the respondents before the House of Lords, and it was for the purchase of 12,000 metric tons of white crystal sugar on FOB terms. And critically, the contract incorporated the rules relating to contracts of the Refined Sugar Association of London, which is referred to in the judgment as just simply the rules. And one of those rules, Rule 14, arguably imposed an obligation on the sellers to be able to begin loading immediately after the buyer's vessel arrived. So this, as I say, this was an FOB contract, meaning that the buyer was going to provide the onward carriage from the point of delivery, which would be onto the buyer's vessel. And the question for the court was twofold. It was on a proper construction of the rules being the contracts of the Refined Sugar Association of London. Did the rules incorporate a term whereby the sellers had to have the sugar available when the buyer's vessel arrived within the stipulated period? And the second layer to this question was, if that obligation did exist, then was that obligation a condition of the contract? And those two questions had been answered in almost every possible formulation in the lower courts and in arbitration.
It was incredible in a way how much flip-flopping there was through the various layers on these questions. And I mean that with respect. It was fiercely argued throughout. A lot of legal energy, I think, as it was put somewhere in this decision, or words to that effect. But ultimately, the House of Lords went the way of the original arbitrators, which I found really, really interesting. And before we get into the actual decision, the arbitrators were from the Refined Sugar Association. So it was referred to the Council of the RSA for arbitration. And they answered yes, in effect, to both of those questions that Callum had posed. It then went up to first instance judge on appeal, and then into the Court of Appeal, and then we end up here in the House of Lords. And as it went through those two first layers of appeal through the courts, there were different formulations of that. Some said no to the first question, yes to the second, and vice versa. And I think what's quite interesting about that, just as a bit of an aside, Callum, is we touched on in the last podcast the threshold for an appeal. And I don't know whether you did this, but it won't surprise me if you did as well. But following that episode, I went and had a look at the threshold that was in place at the time. And I believe it's the Arbitration Act 1979. And what we're talking about here is the threshold to appeal on a point of law from an arbitration decision into the court system. And at that time, I'm paraphrasing a bit here, but the main test was that it's one of general public importance, or for some other special reason should be considered by the Court of Appeal. So the test wasn't as high as it was in the later incarnation of the Arbitration Act in 1996, which has the obviously wrong test, or that it's open to serious doubt with public importance test combined. So you've got the two routes through under a Section 69 appeal on a point of law as matters stand at present. But at this point in time, when this case was decided back in the 90s, the threshold was lower as we had anticipated. And I couldn't help but think, I just wonder whether a decision like this that goes all the way through the court system is just yet one more case on the tipping scale to increasing that threshold in the Arbitration Act. I haven't studied it. I haven't gone back and looked at it. I'm sure there's all sorts of commentary on that point. But seeing the cases just in isolation, this case went around the churches, around the houses, and then ends up back at what now I thought, looking at this case in today's day and age, seems pretty straightforward. And, the arbitrators would now be given a lot of deference in the view that they came to.
Yeah, and I wonder if, in a way it looks straightforward now because of cases like this one, but at the same time, if it did really go around the houses, so the arbitrators said, yes, this obligation did exist. There was an obligation to be ready to load, and yes, it was a condition of the contract. It then goes to the commercial court, and the judge there says no. It then goes to the Court of Appeal, and it seems as though one of the judge says yes to both questions. Another Lord Justice says that they broadly agree, but not entirely, also answering yes to both questions. And the third Lord Justice says no. It then goes to the House of Lords, where there's again a dissenting opinion, but overall they come down on the side of the arbitrator. And I imagine the arbitrator probably would have, or the arbitrators, I don't know how big the tribunal was in this case, but they presumably would have watched this go through the courts and arrived at the end with some feeling of professional satisfaction, having seen their initial arguments or their initial position upheld. But it almost when it got to the top level, when it got to the House of Lords, and this slightly goes into the meat of it a little bit, because I think one of the key takeaways from this case is when you're looking at whether a condition of the contract, whether a term in a contract is a condition or a nominate term, it's critical to look at the commercial effect of that clause. And in the context here, the House of Lords, at least the person giving the leading judgment in the House of Lords, kind of came round to say, well, actually, the arbitrator is almost best placed to answer that question. They quoted extensively from the arbitrator's initial award, and said, it's not really for the House of Lords to say what's commercially extremely important when an arbitrator who is dealing with these sorts of disputes day in, day out has taken the view that this is extremely commercially important. So there's almost this bizarre thing where the further away from the arbitrator's award that it goes, the more power the arbitrator's award has as a kind of commercial touchstone for the court.
I think that's a really, really good point, Callum. And I had the same takeaway when I was reading it, in that it starts with the arbitrators. The arbitrators present a view on this obligation, say, yes, it is important. Time is of the essence. And let's get into a few of those reasons in a minute. Sets it out very clearly why, from a commercial perspective, the time should be of the essence in a sale and purchase contract around time-based clauses. And then it goes into the court system, and it almost read like, the leading decision here in the House of Lords was, well, the judge had his or her own view on why this should not be a condition. And it was almost like being plucked out and said, well, there wasn't a whole lot of substance commercially behind that view. It was looking at it and construing the words. Like, there's a whole debate here about what the sugar means. Like, only lawyers can have a debate, like, and then have pages or paragraphs set out on what does the sugar mean in a contract. I'm being a bit tongue-in-cheek there, but there were a few kind of parts of the relevant clause that were plucked out in the court, at the court level, in both levels before it got to the House of Lords, where they were focusing on these particular parts of the clause and then coming up with a construction of that. And the approach because remember, what are we trying to do here? We're trying to assess whether a term is a condition or not. And if it is a condition, it's a condition. If it's not a condition, then you start looking kind of further down the line to see, is this an innominate term or is it a warranty? And that's one of the areas on the dissenting side in this judgment that I thought I wasn't convinced by in view of the last case we discussed on Bungi. But the point here is that you first need to make a decision on how important is this term to the parties? How fundamental is it? Does it go to the root of the contract? Should time be of the essence? Was that what the parties intended at the time they entered into the deal? And the arbitrators are very well placed to make that type of decision. And that's pretty much what the House of Lords is saying here. It's saying, well, arbitrators should be given a lot of deference. And I totally agree, and I'd endorse what you said, that I think the arbitrators here would have received a lot of kind of professional pride. And I think arbitrators should be congratulated and thanked more often than they probably are in many of these arbitrations. And I don't just say about this one back in the 90s. I mean, in today's modern times as well, because they've often had experience as commercial people. They've either been looking at these cases time and time again. They know how it has effect in other cases and what parties expect. I'm not saying that they don't ever get it wrong, but when you're looking at the commercial importance of a term, which is bound up in this analysis of whether a term is a condition or not, they should be given some deference, I think.
Yeah, definitely, and that seemed to be the way that it transpired here. And I think it is often the case still today that the arbitrators in any decision are given a broad degree of deference on the more commercial decision. The more commercial the decision is, the more that you tend to see, whether it's the High Court or the Court of Appeal, in today's cases, deferring back to the decision of the arbitrators on those points. And I suppose the real high watermark for the deference to the arbitrators is the fact that arbitrators are simply the arbitrators of, or are wholly the arbitrators of fact. And even if you get through that higher hurdle for a appeal in today's test, you still can't appeal on fact. You can only appeal on questions of law. So the court almost kind of uses that, I suspect, or the law uses that as a way of saying the arbitrators can understand, and where parties have agreed to go to arbitration, the arbitrators are completely empowered to work out what the facts are in that case. However, if there's a dispute on a point of law, then the court may have the jurisdiction above it to answer a specific legal question. Whereas here, a lot of it, it's almost one of those questions that transits fact and law to an extent. There's almost the fact that construction of a contract can often have the kind of factual element to it. What would the parties? What would a party really have been wanting here? What's the commercial intention of these kind of words? It's quite it's a legal question, but it's on the kind of facty end of the legal spectrum.
Yeah, I know. It's interesting the way you put it like that, and I agree. I totally agree, and I think that's what Lord Ackner was doing here in setting out verbatim what the arbitrator originally said and the reasons that the arbitrator went the way that arbitrators went the way that they did. I think it was deliberate. I think it was kind of putting an exclamation mark on the point that you just made, Callum. And some of those reasons for why the House of Lords, or why the arbitrators originally found that this was a condition which was then endorsed all the way up at the House of Lords level, included one, that the time of delivery is of greatest importance in commercial contracts, and contracts in the sugar trade are no different to any other type of commodity contract.
So just pausing there, Luke, that to me is, it's part of the rationale for a legal answer to the question of construction, but that's almost a factual finding. That the time of delivery is of the greatest importance in contracts in the sugar trade.
It is. It's kind of bound up together, isn't it? It's one of these kind of mixed law and fact questions. You can't make that statement with some understanding of the facts of what it's like to do business in the sugar trade and other trades. And that comes through. It came through in the Bunge case that we discussed in the last episode. Mercantile contracts, commodity contracts, in those, time of delivery is super, super important. And there are many reasons for that. Often the buyer will be arranging subsequent sales. Those subsequent sales, the delivery period will be the same as what's in the original delivery period. Sometimes they're just selling on, and often selling on the margin and on the paper. And they're not really interested in what's happening in the underlying logistics of the commodity trade. They're just selling on the margin and playing speculative trading on the actual market. And so in that situation, if you're a trader that's never actually going to take delivery yourself, you're just going to sell it on, and your subsequent buyer is going to be concerned about the actual goods and getting them and delivering them to the other end, then what you're most interested in is what are the terms that you're agreeing to, and are they back to back? And that's critical, right? And so, okay, that was point number one. Totally agree. There's elements of fact bound up in that statement. And the rules in the particular RSA rule 14 here concerning delivery, the arbitrator said were also of the utmost importance. And in particular, the phrases, the seller shall have the sugar ready to be delivered, and the buyer shall be entitled to call for delivery. Both of those kind of elements of Rule 14 were said to be emphatic, using the word shall. And then, the third reason was about that giving reasonable notice to enable the seller to perform its very important obligations was important, because then it would trigger the commencement of loading and the period for loading. And that was also a very important clause. And then I think the other interesting factor here, and it kind of flows into or segues into a discussion of the dissenting decision, is that the arbitrators said that they do not accept that the payment of demurrage would be adequate compensation for the buyer in the circumstances. So for many of you listening in, you'll know what demurrage is, but it's a form of liquidated damages that's agreed in advance, a figure in the contract to compensate for delays in a contract. And the arbitrators were saying that some type of demurrage rate in the sale and purchase contract would not be sufficient compensation in the event of missing a loading period. Because, as we've described, there's all these potentially follow-on effects of missing a delivery period. And then, Callum, the Lord Ackner goes on to emphasise that, or endorses those very points that the arbitrators originally made.
Yeah, exactly. Here are the points that the arbitrators made, and I endorse them. And one other point that I thought was quite interesting in there, kind of bundled into this point about demurrage, is that the way that the contract is structured is there's this big delivery window where the parties agree that the sale could happen at any point within this window, but it's the buyer who gets to nominate when the ship arrives within that window. So the window might be, let's just say, from the 1st of January to the end of February. and the buyer then nominates a 2-day period within that window when the ship's going to arrive and they want to load and effect the sale of the cargo. The arbitrators found that the length of time that the buyer was able to negotiate was a valuable option to the buyer, because the buyer is then in a better position maybe to agree an onward sale, or they perhaps have more flexibility in when they can put a ship into collect the cargo, or maybe they've got more flexibility about at what point they actually take the cargo. If the price is fixed, at the time of the sale being agreed, then they may have some kind of arbitrage in taking the cargo on a specific date versus a different specific date. For whatever reason it is, if there's a long period within which the buyer can say, "I would like the cargo, please," then there's value to it. And the arbitrators kind of found that was almost priced into the price, and it would be odd if they came to a decision that took that right away from the buyer by saying, actually, you telling the seller that you're going to arrive on this specific date and the seller not giving you the cargo it's okay for the seller to do that, or the only remedy that you get from the seller is demurrage. They said the buyer's actually got something more important than simply a right to demurrage. They've got an option about when they pick up this cargo. I thought that was an interesting point.
Exactly. It's really well explained, if you don't mind me saying, Callum. And there's a point in amongst that I thought just to emphasise that might not be that apparent or that obvious, but it's this arbitrage point that you make about how trading commodities work. You might have a spread of 30 days for loading in, say, this particular contract you're dealing with, where you're the buyer of the goods, and that covers 30 days. In this case, it was sugar, where you have the option to call for that cargo within that 30-day period. But then on the market rises. You're now a seller selling that same cargo to your buyer, and somewhere in that period, you want to actually narrow the loading period to, let's say, the last week of the 30 days that you had in your original contract. And if you agree on just the 7-day period at the end of the 30 days, because the market has gone up with your buyer, you might be able to fix that at a higher price. And so what you're then making, as I said before, you might not be interested at all in the actual logistics of the trade. You just go back to back on the underlying terms. You have a different period of loading, but it obviously overlapping, so it's within the other one, and you're making a margin. And that's the business model, right, in many ways. And if you can't be sure that you're going to have that cargo within the 30 days, you're going to be exposed to damages to your buyer, and you're going to miss out on the margin. So that's why a demurrage type compensation, which is compensating for time, albeit pre-agreed in advance, and it might factor in other things than just time, doesn't really lend itself well to covering that type of damages claim.
Yeah, exactly. And maybe with all of that background, all of that kind of commercial rationale, is helpful to look at the specific terms at issue here. I did wonder when I was reading this whether the judgment itself is actually better as a broader principle than it is on this specific question, because in some ways it's a reasonably narrow question, which gives rise to quite a broad kind of general statement of law. But I think it's worth going through the contract anyway. So there are two different parts of the contract, effectively. And anyone who's in the international trade world will be kind of familiar with the idea of having a front end contract and then a set of rules that are incorporated. And it seems like that was the case here. So you had clauses 7, 8, and 9 of that front end contract. Clause 7 was delivery, and it said to one or more vessels presenting ready to load during May, June 1986, buyer to give seller not less than 14 days notice of vessel's expected readiness, such notice to be given on a business day in seller's country prior to 1600 hours London time to be effective that day. And 8 was the price. It simply set out the price and said that it was FOB. And then 9 was loading and said the seller shall load the sugar at a rate of 750 metric tons per weather working day of 24 consecutive hours, basis 5 or more hatches, demurrage and dispatch as per charter party rate for seller's account. And if you pause there, and that's the only part of the contract that you have, then it was common ground that under those terms, there was no obligation on the seller to have the sugar available to begin loading immediately when the vessel arrived at the port. There was a liability in demurrage if the sellers failed to load within the number of lay days that you would derive from the calculation of 750 metric tons per day across the entire cargo. But there was not a specific obligation to be able to start load immediately. So the question was then: do the rules change? And in particular, Rule 14, does it add to the contract in a way that imposes that obligation? And Rule 14 is reasonably long. There are a couple of sub rules that I thought were quite important. The first was Rule 14, Sub-Rule 1, that said, in cases of, it includes FOB, contracts, in cases of FOB contracts, the seller shall have the sugar ready to be delivered to the buyer at any time within the contract period. And the other sub-rule that was pretty important to me was Sub-Rule 14.4, which said, if the vessel or vessels has presented herself in readiness to load within the contract period, but loading has not been completed by the last working day of the period, the seller shall be bound to deliver and the buyer bound to accept delivery of the balance of the cargo or parcel up to the contract quantity. So the effect of Rule 14.4 is effectively that if the sugar wasn't there, but it could, some loading could be, if the sugar was not there and loading hadn't been completed by the end of the working day of the period, then the seller remained bound to deliver and the buyer remained bound to accept the delivery of the balance of the cargo, which almost put a kind of open-ended, gave the contract a kind of open-ended structure unless there was a condition of the sort that the buyer was arguing for. Unless the buyer could say, actually, I choose to walk away because you failed to deliver the cargo, then under Rule 14.4, it seemed to me that the contract could, in theory, go on almost indefinitely with demurrage accruing and accruing and accruing.
Yeah, I see that. I think that's right. And then, if you go back to the first of those provisions that you went through, or what was called Rule 14.1, although I think the actual sub numbers weren't there in the original clause, but for the ease of use, it's been called 14.1. The first issue was this question of the sugar, which I talked about earlier, and the Court of Appeal approached that. And indeed an argument before the House of Lords that was a crucial question, and whether that meant the entire contract goods, whether or not the buyers had exercised their option of taking delivery in one or more lots as provided by Rule 11. And this, then went into the point about Rule 14.1 to 3, which all referred to the sugar. But the House of Lords, and particularly Lord Ackner, were of the view that Mr. Morbick's submission on that kind of overlooked what the sugar meant, and that it was clear that the sugar must refer to the entire contractual quantity of sugar or to any lesser quantity for which the buyers may have called for if they had exercised their option of taking delivery in one or more lots as provided by Rule 11. So there was this ability within Rule 11 to call for a lesser amount. And if that was the amount that the buyers required and that they called for, then that would be the sugar. It didn't mean that it had to be all of the contracted goods delivered within that period of time, which we can see how that might not have even been possible. So anyway, that was one point that was taken up. Then the next point or kind of breakdown of Rule 14.1 was the meaning of ready to be delivered. Did you want to take that one, Callum?
Yeah. So the argument here is almost how if this is a condition, if it's a condition that the sugar must be ready to be delivered whenever the buyers ask for it, then that puts a really difficult burden on the seller, because how are we going to have all the sugar stacked up beside the ship waiting for it to come in? It's unworkable, it's uncommercial. And the court kind of found that what was meant by ready to be delivered was not that it was all stacked up and set out on the quayside waiting to be loaded onto a ship. What it meant was that the goods should be, and they quoted from the case of European Grain Shipping against David Geddes, which is a 1977 case that looked also at the question of the goods being available for delivery. And they endorsed what the judge said in that case, which was that the goods should be in such a state of availability for delivery from and including the first day of the delivery period that they can be delivered to the buyer as soon, in a commercial sense, as the buyer requires the seller to deliver. So although this is a condition of the contract, the requirement is not that the seller has the goods kind of, immediately accessible. It's that the seller has the goods, there or thereabouts, but ready to be given to the buyer in very short order, but with kind of normal commercial tolerance applied.
And then that flowed on to the third aspect of this clause that they looked at, and that's the meaning of at any time within the contract period. And the argument here by Moore-Bick, as he then was that it didn't really make sense for the sellers to have arrangements in place during the whole contractual period, so that these goods were always sitting there ready to go for the whole period of time, and that at any time within the contract period does not mean not at all times. So he was kind of drawing this distinction between any and all, I think. The decision here was that it's almost coming back to the point that you made earlier about the purpose of having a buyer's call, right? Where this was, the clause was set up in a way that gave the buyers a call or an option, is another way of putting it. Not perhaps as high as a demand, and there was some debate about whether a call is the same as a demand in the courts below. That really wasn't the point. The point was that the clause was set up in a way so that the buyers had the option here. They had the call, they had the ability. The leading decision here kind of restated Rule 14.1, I think, quite helpfully, to say that what the term really means is that the seller shall have the sugar called forward, available for loading, without delay or interruption, as soon as the vessel is ready to load the cargo in question. And when you think about it in that way, I think it does make sense that, as you say, on interpreting the prior point, that the cargo needs to be available, ready to be delivered on the buyer's call. It doesn't all need to be packaged up, sitting there, on the quayside for the whole time, but it needs to be available. And that's really how. There was a lot of debate about this, and this is where it talks about that. The House of Lords said that it's understandable that much time and intellectual energy was expended in the Court of Appeal in considering, the other decisions and these points. around what does buyer's call mean and this and that. But really, there was an additional express obligation on the sellers to have that cargo ready at buyer's call. That obligation was brought in through Rule 14, and they were in breach of it. And that was really the end point to the first question, agreeing with what the arbitrator said at the first go at all this. And then the second question was, which we've discussed a bit already, whether that was a condition, whether that additional obligation was a condition or not.
Yeah, exactly. And this is where it's helpful to listen to the episode 49 that we recorded that went out last week, because the decision that we have here, the House of Lords in this decision, we're really looking back and applying the principles set out in the decision in the Bunge and Tradex case that we discussed last week. It really follows very closely the fault lines of that decision, and this is really where the House of Lords, I guess, solidified that law is an appropriate way of looking at what's a condition and what's an innominate term in the mercantile sense. And again, there was a lot of influence drawn from the court here on the from the arbitration award itself. I'm just trying to find the phrase. Yeah, it's page 1347 of the law reports, and at the very bottom of that page, the Lord Ackner says, "It will be recalled that in paragraph 14 of the award set out above, the arbitrators considered Rule 14 as being one of the utmost importance." And again, there's that reliance we spoke about earlier in the podcast of the House of Lords in looking down to the arbitrators at kind of the bottom of this legal chain of inquiry to guide them on what's the commercial importance of this provision. And again, we see the same conversations that we saw in Bunge and Tradex, where they say that firstly, the court shouldn't be reluctant to hold that an obligation has the force of a condition. I think secondly, you have a parallel between this case and the Bunge case, where the only way that you can breach the relevant clause is by being delayed, by causing delay in a mercantile contract. There's no other type of breach that you could have here. It's all about delay, and where time is of the essence in a mercantile contract, or where you have time clauses in mercantile contracts. There's a sense that it's it may be of the essence. There was a kind of interesting point, which is taken from the Lord Lowry's comments in the Bunge case, where he says the treatment of time limits as conditions in mercantile contracts does not appear to me to be justifiable by any presumption of fact or rule of law, but rather to be a practical expediment founded on and dictated by the experience of businessmen. So it's not the case that where there's a time limit in a commercial contract, it's automatically a condition all the time because of some strict legal reason. It's just that in the cases that the courts had been through, in particular the Bunge case that we discussed last week, in this case, the court was finding that it was practically expedient in the experience in the commercial experience of the people who actually were entering into these trades for a time period to have the force of a condition rather than an innominate term.
Yeah, exactly, Callum. You're right. And the court here, Lord Ackner, went back and looked at the much earlier case of Benson and Taylor in 1893. And I think that's a helpful case to go back to look at as well. Admittedly, it was looking at it through the prism of condition or warranty without much discussion about innominate terms. So I wouldn't take it in isolation, but on the point of how to look at whether a term is a condition or not, I think it's quite instructive. And the quote that's set out here, and I think I'm going off memory, but I'm pretty sure it was quoted in the Bunge case as well, is that there is no way of deciding that question except by looking at the contract in the light of the surrounding circumstances, and then making up one's mind whether the intention of the parties as gathered from the instrument itself will best be carried out by treating the promise as a warranty sounding only in damages, or as a condition precedent by the failure to perform which the other party is relieved of his liability. And I just think it's important to not think about these types of provisions as black and white. Yeah, if it's a time-based provision, it's definitely a condition in a sale contract. No, that's not the way to look at it. Yes, you're going to be thinking in those terms when you have a time-based provision, but actually what you need to do is go back and look at what the intention of the parties were in the surrounding circumstances and what would have been the effect of it. And we've talked a lot in this podcast and the last one about the commercial reality. And as you say, Callum, the court here emphasised in multiple occasions that what the tribunal said deserves some respect and deference, and to put a exclamation mark on that, even when deciding the point on whether this provision was a condition or not. Lord Ackner said this: "To my mind, the evaluation by this experienced trade tribunal of the commercial significance of Rule 14.1 was wholly justified." So it's not like it's just coming at it afresh and saying this is the principle, it should be applied. It's like the tribunal looked at this. It's an experienced tribunal. They found this way, and I think that decision was justified. It's a language. I'm talking about language usage here, but it's language usage that makes a point, and I think it's really instructive and brings us right back to where we started this podcast on the thresholds for appealing arbitrators' decisions and on points of law, on errors of law. And yes, you can. We've had recent cases where we've appealed on arbitrators' decisions through the current threshold there is on the Arbitration Act. But it's set up in a way now where I think the example of this type of case, Callum, comes through in how courts consider whether to give leave or not on original decisions, particularly in the commercial space like these ones.
One of the key takeaways from a case like this, how does looking at a case like this shape our practice today? And obviously we have the ratio of the case and we have the impact of the case, but also those procedural points are so important to have in mind, and the background to the laws that we have now on procedure are all informed by this type of decision.
Should we mention, just in passing before we wrap up, I know we've probably gone on for a bit too long, but it is our 50th episode, so we weren't going to make this a short one. Did you want to say anything about Lord Brandon of Oakbrook's decision, just in passing?
I thought you might be going there. In some ways, quite a sensible dissent, because effectively what he said is there are a number of different clauses in this agreement that deal with delay, or there are a number of different clauses in this agreement that stipulate a time for performance, and none of the other ones are given the effect of a condition. In fact, in other cases, they're expressly not conditions. They're expressly made good with damages. For example, demurrage. And he said it's odd, or I think he said, let me see if I can find exactly what he said. Illogical, that's it. It seems to me to be illogical to interpret the contract with its incorporated rules in such a way as to classify two obligations, the breach of which would cause delay in the loading of the ship, as warranties, and another, the breach of which would have the same effect as a condition. In each case, what matters to the party to whom the obligation is owed is the result of its breach, namely delay in the loading of the ship. And I think in some ways that's quite a persuasive point. I think the issue is that it's a different character of delay between the two, between the sugar being there, but there being some other issue that delays the ship, and the sugar simply not being available, and the sale being delayed for that reason. I think that's where you get past this, but in some ways I thought it was quite a forceful dissent.
Yeah, I see that. I also wondered though how it sits with the concept of anonymous terms, because he's kind of gone from thinking about or considering this in terms of is this a condition or not, and then almost jumped into the gravity of the breach analysis without expressly doing so. So it's not like he's found expressly here. I don't think it's a condition. I think it's an innominate term. And then when you look at the consequences of the breach, I don't think it's sufficient enough to be able to rescind the contract. It is almost still like in the old way of looking at it, pre Hong Kong fur and pre Bungie, and I just thought it just seemed to. I take your point, and I think you're right, and I say it with the greatest respect, but it just seemed to me that it wasn't actually looking through the prism of this kind of hierarchy of three types of terms that we know so well now. Anyway, interesting. I thought it was a great case. I've enjoyed looking back, Callum. In New Year, why don't we get into some recent cases? We'll take our audience back to looking at updated cases and things from this age. But I think it's really useful. I'd encourage everyone, if you haven't already, to go back and listen to the last three cases. I know that it's in part been because I'm preparing for this course coming up that we've done them, or in very large part. But it is really interesting to go through this exercise. I've enjoyed it, Callum.
I'd like to do a similar thing, every now and again, take 3 cases, 4 cases, whatever it is. And, all of the cases we've done here have been about the effect of certain terms in sale agreements, whether they're conditions or innominate terms. And we can similarly do something on damages, whether it's damages under a charge party agreement, or whether it's damages under a sale contract, or there are a number of these types of cases that come in small groups that together paint quite a good picture of one area of law. And I think it might be something to incorporate from time to time on the podcast. Maybe during the court's holidays, we can throw in some of these periods of looking at specific issue through a lens of historic cases.
Sounds good to me. There's an idea for next year. So look, Callum, congratulations again.
Thank you, Luke.
Partner chain. And have a good break, everyone. If we don't speak with you before next year, happy holidays. I hope you enjoy the festive season. We've very much enjoyed and welcomed and are grateful for your patronage and listening in to the podcast this year. We've had some really interesting guests on. Thank you to our guests. And we hope you've enjoyed it. I know I've certainly enjoyed it, and I'm sure you have too, Callum, eh?
I have too. Wishing everyone the best for a happy new year.
Till next year, take care.